All right, we are going to go ahead and get started. Welcome everyone to the Marble webinar. Today we will be hosting a community Ask Me Anything Q&A session with family attorney Jeffrey Pollak. Thank you to those who joined our last webinar in June and provided feedback. We've incorporated your feedback and have changed the dynamic to allow for a completely open forum where the majority of time will be spent answering live questions. So to kick us off with an agenda, just a couple of things to start. We're going to set some expectations for the webinar, just a couple of housekeeping things. I'll tell you a little bit about Marble and then introduce Jeff. And then we're going to go ahead and open the floor for questions. At the end, we're going to select a winner for 25% off legal fees with Marble. So we do encourage you to stick around, and then we will wrap up with some closing statements. So to start with some housekeeping things. So for privacy purposes, your microphone and camera will remain off for the duration of the webinar. Questions may be asked via Zoom webinar Q&A function, which can be found within the Zoom controls. We ask that you please ask questions anonymously by checking off the Ask Anonymously box. For privacy purposes, please avoid sharing names of parties involved with your case or any other identifiable details. Poll questions will be asked throughout the event. Answering is not a requirement, but will be anonymous. And as mentioned, a participant will be selected at the end for 25% off. This will be done via Zoom through the chat function. So we will give you more details once we get to that part. And lastly, as you probably all heard, this webinar is being recorded, and we're going to send along this recording as well as a copy of the presentation at the end of the webinar for your reference. So to kick off, I'm just going to tell you a little bit about Marble. For those of you who may not know much about Marble, I wanted to give a quick overview. So Marble is a new kind of law firm that believes everyone everywhere deserves access to remarkable legal care. With a fast digital onboarding process, a flat fee upfront price with the option to pay over time, and a dedicated team of attorneys and case leads who put their client needs first, Marble has reimagined legal services to provide people with an easier, transparent, and more human experience when they need it most. So Marble is currently available in California, New York, Texas, Florida, and Arizona, and we continue to expand nationally. If you're looking for more information, you can visit our website, themarbleway.com. And without further ado, I'd like to introduce you to Jeffrey Pollak. So Jeff is a California licensed attorney and the principal attorney for Marble. He has over 15 years of experience providing quality legal services to a diverse group of individuals and businesses. With an emphasis in business, real estate, and family law related matters, both litigation and transaction based, he's had the opportunity to counsel clients in a wide variety of matters spanning across the legal spectrum. With his pragmatic approach to the practice of law, creative problem solving, and a focus on always putting the client's needs first, Jeff has helped Marble take great strides towards our goal of making legal care accessible to everyone. Beyond being an attorney, Jeff enjoys spending time with his family, coaching little league sports, and he has a passion for music. So welcome, Jeff. You want to say hello?
Absolutely. Thanks so much for that, Amanda. I really appreciate the warm welcome, and it's exciting and fun to be doing this again. Our last one I thought went really great, and we definitely listened to the feedback. And I think a consistent theme was, God, we just wish more questions could have been answered. And so we really went in depth last time into a lot of topics, and hopefully what we're trying to do here is see if we can answer more questions. May not be 20 minutes on each topic, but what we're going to get is a broad overview of whatever the question might be, try to give really practical answer, which will provide, a sort of a real world analysis of what's likely to happen and what sort of issues might come into play based on what the questions are. I don't know what they are going to be. So, obviously do my best to answer the questions on the fly, and really appreciate everyone joining. Like we said last time, I think it's just important for everyone to know, obviously, this is a public forum. There's so much more information and details that any attorney, myself included, would need to answer a specific person's specific legal question and how it might, apply and what the likely outcomes would be. There's just a lot of other factors that would be involved. So I think it goes without saying, but no one should take what I'm saying as legal advice that applies specifically to your situation. It's generally the concepts will apply, but there's a lot of other factors that would have to be taken into consideration. So highly recommend you contact an attorney to help you with your family law matter. Of course, we're happy to help, but as I always say, whether it's us or someone else, I just highly recommend that anyone dealing with any legal issue, family law or otherwise, you go to a legal professional. It's what we're trained to do and what we're here for.
All right. Thank you so much, Jeff.
Absolutely.
All right, so without further ado, we're going to open the floor for questions. I'd like to mention that you need to use the Q&A function in the Zoom control. So you'll see Q&A. I see some questions already starting to come in, but we will be selecting questions from there. So feel free to ask away.
I see some questions rolling in already.
Yep. All right. All right, Jeff, we've got the first one here. I'm going to go ahead and answer live. So the first question is, what is the best way to win a mediation for child custody?
Best way to win a mediation for child custody. The first thing I'd say is if you're in mediation, everyone should understand what that means is both sides have decided they're going to try to go to a neutral, this neutral party who doesn't have any skin in the game. Their job is to try and help the parties come to a resolution, reach an agreement that would be at least satisfactory to both of them. So when we say win at mediation, it's like it's a contest, which I fully understand, believe me. But I think anyone who's going to mediation should be thinking to yourself, I'm coming here. I want to see whether I can make a deal with the other side. This is a stressful time in my life. And if the parties can find a way to agree on things, even if it's not everything, it's a great first step towards the rest of your lives. And let's face it, whether you like it or not, if you have kids together, whether or not the marriage worked out, you guys are still tied. And so when we're talking about winning at child custody, let's reframe it and say, what's the best way at mediation to get the most favorable outcome? When it regards to child custody, I would say be the best parent you can, have a track record of showing your level of involvement, and also how well you can communicate with the other parent. A lot of times factors that will go into play in a child custody matter that a judge might look like if you're not able to resolve it is, how likely is this person who I might be willing to give custody to, how likely are they to have open communication with the other parent and let the child see the other parent? Because the last thing a judge wants is to give custody to one parent who's going to keep the child from the other parent. The law wants children to have as much frequent and continuing contact with both parents as possible.
That's great. Thank you.
Yeah.
All right, we got one up here. This one is child custody related as well. Let's see. So the court has ordered my ex and me to start co-parenting counseling as a condition for 50-50 timeshare. I have only 40% right now. What is co-parenting counseling? What are the gotchas I need to be aware of?
That's a good question. So look, I think for at least for California, in a bubble, a court would love to see two parents who are not going to be married any longer have a 50-50 timeshare, meaning the children get to see both parents equally. Co-parenting counseling is going to be they're either courses or they could be one-on-ones where both parties are going to learn techniques and strategies for best parenting a child when not living in the same house, when there may be personal disagreements. There might be a new spouse involved or a girlfriend or a boyfriend. And so these co-parenting counseling they're really designed, that the process is designed to give the parents the tools that they need to navigate very complicated waters. Somebody you were married to at one point or had a relationship with at one point, and now it's not working out. And usually that means when you don't have kids, well, maybe I'm never going to see this person anymore. Like it or not, you're tied to each other as long as you have a relationship with your kids. And so it's just helping you have the tools to be the best parent you can, which starts with your ability as parents to communicate well with each other. In terms of the gotchas to be aware of, sometimes parties will try to see if they can show that there's bad communication, that they're trying to ask for things in writing or over the phone and the other side fails to respond or refuses to cooperate. And so I think, especially if this person only has 40% now and wants to get to 50%, it's all about putting your best foot forward. It's all about showing when you go back to court for that review, number one, that you did the courses you were ordered to. So you have to do it. If you don't do it, that's not a good first step. And number two, just showing that you really are taking the skills you learned to heart, and that your goal, your focus is to be the best parent you can, and that you understand this means you really need to try and work on the communication between the parents.
Awesome. Great. Next question is, what is an RFO and when is the right time for me to use it?
It's a good question. So an RFO is something you'll hear family law attorneys say a lot. RFO stands for request for order. And really what that is in California is the specific judicial counsel form that is used to ask the court or a judge to give you something. It's really, in the civil world, what it's called a motion. It's where you're basically making a request for order, request for an order from the court on whatever topic it is you need, that you want, and that the other side and you cannot agree on. You can always agree on things, and then you don't need to go make a request for an order. You can just agree on the issue, and then you can put it into what's called a stipulation, which is a fancy word for an agreement. And they're called stipulations and orders. And you sign an agreement, you give it to the judge signs the order. Now it's an order of the court. We're talking about anything. It could be who's going to use the car, who's going to be responsible for paying for the cell phone bills, any of the little things that might happen during the course of a family law matter. If you're not able to reach an agreement and sign that stipulation and order, then you need to request an order. And that's where you use a request for order. Essentially what it is, judge, I need something, the other side won't give it to me, and I want you to make an order that says, this is the deal, this is what needs to happen. And once you have an order, frankly, even if you're on good terms and you're agreeing to things with the other side, I still recommend putting it into a stipulation and order, because then it becomes enforceable. Now you have a legal document that says you're entitled to these things. Whereas if it's just an agreement, the person can stop agreeing to it if they want. And who's to say it really was an agreement? And so even when things are amicable, I recommend getting a stipulation in order, make it an order of the court. It's like I would say to a business client, for example, if things are great, you can do things on a handshake. I think contracts are best, just to make an analogy, contracts are best for people that are getting along. It's the best way to ensure they'll keep getting along, because it's very clear what is going on. It's very clear what the rights and responsibilities are, and it prevents disagreements from happening. And so I sort of have the same view when it comes to these kind of things.
Great. Next up, are the parties in a divorce able to use one party's pension money to pay for their joint debt?
Oh, that's a good question. I feel like I have like 10 follow-up questions to ask before I can really answer this question. So are the parties in a divorce able to use one party's pension money to pay for their joint debt? The reason I say this is are they actually actively in a divorce case? Has the divorce case been filed? That changes something. Pension money can mean a lot of different things. Is it like an IRA? Is it a 401k? Is it just a retirement account? And those things do matter, because certain retirement accounts are governed by federal law, other ones aren't, and that can sort of it can move the needle and change the analysis. Here's the thing: when you file for a divorce in California, the person who files will get back what's called a summons. The moment they file on that summons, and you can go look at it, you can go Google it and pull it up on, you'll see that there's a box in the summons that has what family law attorneys call ATROs, ATROs, automatic temporary restraining orders. And these are temporary restraining orders. So they're restricting the ability of a party to do certain things, like change the terms of a trust, for example, or borrow money. Okay, these are automatic things you're not allowed to do the minute that you file for a divorce. And on the flip side, once the respondent, the person, your spouse, the person who will need to respond to the filing, the petition for dissolution of marriage, once they're served with the summons, now they're bound by those automatic temporary restraining orders. And so we need a lot more details, but if you take a look at those, you'll see that, borrowing money is something you're not allowed to do. Incurring an obligation is something you're not allowed to do. When you're dealing with retirement money, it can get tricky too, because for some types of accounts, if you withdraw that money before retirement age, you get it with penalties. And let's remember that in California, it's a community property state. So all money you earn from working is community property. And if you withdraw it and the court didn't say you could, for example, and there's penalties, it may turn out to be like extra negative, because now you've not only maybe taken out money you weren't supposed to, but you've also incurred sort of a liability to the community in that you had to pay penalties as a result of taking it out. And so you may end up actually owing your spouse more money than you actually took out. So this is sort of a very complex issue. But that's sort of, I think, the best I can do based on the information that I've got to look at here.
Awesome. Thank you. So just a reminder to everyone, just make sure that the questions you're sending through, you're not including details that could be identifiable. And on top of that, please make sure you're putting it in question format. I see a couple statements coming through, but we want to make sure we can answer questions. So this next one, I'm going to rephrase slightly, but so basically, what does visitation look like when there has been a case of abuse on one side of the family?
What does visitation look like when there's a case of abuse on one side of the family? Okay, so it's a good question. It will depend on what the abuse is. It will depend on whether all we have is an allegation of abuse versus an actual finding that there has been abuse. So that's obviously a very big difference. Somebody saying that person abused me, and I'm going to go out on a limb here and say that person being accused of abuse is going to say, no, I didn't. So now you have who's right? Who does the judge believe? So that's one thing. And then the other thing is somebody made that allegation and it was brought before a court, maybe in a domestic violence restraining order request or something like that. And the judge found, yes, there has been domestic violence, huge impact on visitation. So first of all, you should know, I think it's Family Code 3044 says that in the case of abuse, domestic violence, there's a presumption. It's a rebuttable presumption, which means it's not, this is the end of the road, but it's presumed that a person who has been found to have committed domestic violence, that giving them sole or even joint custody is not in a child's best interest. So that's just an automatic presumption. It's rebuttable. Like I said, it's not like, and that's the end of the road. It's now the other side, it's called a burden shift. Now the person who's been found to have committed domestic violence, it is now their burden to show, notwithstanding the fact that they have been found to have committed domestic violence, it would not be in the child's, it wouldn't not be in the child's best interest. It's not great English, but you understand the point, to grant that person sole or joint custody. So it has a huge difference. What you'll see in these cases is either no custody at all and no visitation at all, zero contact order, or perhaps supervised visitation, which is, it's challenging. Obviously, if you're the custodial parent and the other parent is the one that has perpetrated domestic violence, even though it's probably very challenging for the kids to have this stranger that's always around when they're with the other parent. And I have no doubt it's very hard for the parent who committed domestic violence. For me, but this is just me, I hope it's actually not just me, I don't really care about that parent who has perpetrated domestic violence. In the sense, I care about everybody, but I don't care about that person's feelings when it comes to protecting a child, when it comes to protecting and doing what's in the best interest of the child. If a court found that domestic violence has occurred, and supervised visitation is the way to best ensure that there's some monitoring of what's happening, no matter how tough it is, I obviously am in favor of it. I think I would hope everybody would be, but it has a substantial impact.
Thank you. I think that's a good segue to our first poll as well.
Cool.
All right, so the first poll is a true or false question. Feel free to answer. So I have dealt with a traumatic family event in my life, and we'll give you 15 seconds to answer.
That would be like either themselves or a family member or something like that?
I guess, yeah, themselves.
Okay.
We got a lot of responses coming in.
See that.
Right, they're slowing down, so I'm going to go ahead and
Cool.
share. So if everyone can see the poll results, you'll see that 78% of participants answered true and then 22% answered false.
I think this is, I don't know about you, Amanda, happy to get your thoughts on this, but I'm not, it's sad to see. I think that the 22% that have not had to deal with a traumatic family event are really lucky. Many people do have to. I think people in the midst of family law issues, almost by definition, in many cases, it's a traumatic event because it's a total upheaval of life potentially. Now, what people don't realize is life does go on, and we're all creatures of habit. And at the end of the day, it's a change. And I don't know about anybody else, but I hate change. I'm a big creature of habit. I just want things to always be the same. And so it's really very turbulent. So I'm not surprised to see that. I'm sorry to see that, but I'm not surprised.
Same here, yeah. All right, I'm gonna go ahead back to the questions here. Let's see. All right, so this next question is a common one, so I'm gonna go ahead and do that one. How long does the divorce process take, especially when both sides agree?
Great question. And I love the fact that both sides agree. I'm a big proponent of that, and not to say that I have negative views of people that can't agree. It takes two to tango, as they say. And many times you've got one person that would love nothing more legitimately to just agree, but it takes a partner. You got to come to the table together to do that. The length of time, I can say this, the absolute quickest that you could ever get a divorce from filing to stamp on the document, your divorce, is 6 months. That's just a jurisdictional requirement. State of California there's a residency requirement of 6 months. And so to make sure that that's met, they won't issue a divorce until 6 months after it's been filed. However, if both sides agree on everything, I'll take you through an example of how quickly you can be done, in the sense that all the heavy lifting is over. You could theoretically file your paperwork on Monday, and on Tuesday, this is a lofty goal, but it's theoretically possible. You file everything. You file your initial paperwork on Monday, so you're opening the case. On Tuesday, you could have all the documents signed, the agreement signed, all the various forms that you need to get the order, and you could be done. You now have a binding agreement between yourselves. You'll submit it to the court. The court may even give you an order back. The next day they could, but it will say on that form, this is done, and here's the deal. Your divorce is effective 6 months from now. Like, it'll have a date specific in there. If it's January something, it'll be, June or July something down the road, which you write in, your attorney will write in advance, just knowing the jurisdictional requirements. But it can be as actually doing the deal can be as quickly as the parties can come to an agreement on everything, and the attorneys can write it all up. That's the only limitation.
All right, next one. How does division of assets work? We have filed for divorce, but not made any progress on financial matters.
That's a good question. And that's, honestly, this is where a lot of cases get stalled in the court. It's a big question. How do the division of assets work? They work both very simply and in a very complicated way, all depending on what kind of assets we're talking about. So dividing a watch or two watches is a lot easier than dividing a house or 5 rental properties or a very valuable piece of art or something very sentimental to both parties, right? So it all just depends. The way it works is either the parties will agree on how they're going to be divided. And parties don't, it's not all or nothing game. Parties do not have to either agree on how everything's going to be divided or forget about it. We're just going to leave it up to a court. You can agree on what you can agree on and leave the balance you can't to the court. You're making life a lot easier for yourselves in the court, which the judge will be happy about. And it's good for you because you've found some common ground, even if it wasn't everything. But ultimately, it's going to be up to the court. It's such a complex question. How does it work? Because that can have two components. One is like, how do you actually physically say you get this and you get this? The other one can be we have this asset and it was bought before marriage, but then a bunch of money was put into it after marriage. So how do you divide? It wouldn't be 50-50. How do you actually decide what percentage this person gets versus what percentage of this person? It's complicated. By and large, I'll try to make it easy though. Here's the rule. In California, everything, I'll give some exceptions in a moment, but everything that you get as a married person from the date of your marriage is community property. What that means is both parties have, essentially like a 50% interest in whatever that is, particularly earnings, anything you get, and anything you purchase with community property money also is community property. So if you have a bunch of 20 grand in the bank from working and then you buy a car with it, but you're the only one on title, it doesn't matter. It's community property because the money used to buy it was community property. The exceptions to that are if even during marriage you get something by gift, if someone gives you a gift, just you, that's yours, separate property. You can change that by adding your spouse to the bank account that gift was on. Okay, now you've potentially what's called transmuted it or turned it into community property. Or if you get an inheritance and things like that, then those are separate property. Where it gets complex is, say someone buys a house before marriage with money they used before marriage. Let me back up and say, the opposite to separate community property is separate property. Separate property are things you acquire before you're married, and the things you acquire during marriage by gift or an inheritance, and the things you acquire not after divorce, but after separation, which can be a complicated issue on its own. Where it gets complex about how to divide assets is, let's say I have a house and I bought it before I was married. I put the down payment, I got the loan, house is in my name. And then I get married. Never add my wife to the title, but how am I making the mortgage payments? I'm using money from our joint account. And in our joint account, that's money from my paychecks deposited into. Well, now I'm slowly but surely contributing community property towards the house. And if we need a new roof and I'm using money from that account, well, now I'm contributing to the improvements on the house. And now you get into like a much more complex analysis of what percentage of this home is separate property, what percent is community. And of course, the part that's community is itself divided in half. So 1/2 of the community is yours and 1/2 of the community property is your spouse's. So it can be complicated. And because of that, again, I'll say, if you can agree on stuff, it's much, much better. But you shouldn't unreasonably agree on stuff. So I am very much in favor of being reasonable and bending a bit. But that also doesn't mean being taken advantage of, unless you find that allowing yourself to be taken advantage of is good for your mental health, or you decide there's more important things in life. That's a very personal decision for everyone to make. As an attorney, I'm always fighting for my clients. But there's other factors that are in play always.
Some things are worth fighting for, others you just want to wash your hands and walk away.
That's exactly right. And I can't tell you what those things are, just like you can't tell me what they are. We may have very different things that we are willing to wash our hands of or willing to fight for.
Very much. For this next one, I see a handful of questions coming through around the same type of topic. So I'm going to consolidate because I think it would be helpful to address this. So a lot of people are asking, how do I get legal help with Marble, and how much is the flat fee?
It's a good question. Mm-hmm. Well, the way you get legal help is you give us a call or you contact us through the website. How much is the flat fee is a very challenging question, because it really all depends on what it is that you need help with. And not everyone's problems are the same. Not everyone's issues are the same. The things that need to be done in order to help each individual person are different, just depending on what their circumstances are. So what we typically do is we take things on a flat fee basis, broken up in a service by service fashion. So, you're not getting, you don't get billed by the hour through our firm. We do everything on a flat fee, and we provide payment plans to our clients as well, just to hopefully help in providing access to attorneys who just really think it's important. But it really will range anywhere from, on a per service basis, $1,000 to, $6,000 or $7,000, depending on what it is that needs to be done. Obviously, helping a client who has a deal completely done, and we're helping them, which gives, we smile when this happens because we want to help people, and this is a great ideal solution. Obviously, it's a different fee to help someone who's really got all their details worked out than it is to help a person who, is in a very complex valuation issue, or there's very heightened child custody and visitation issues that are at play. When you got to go ask a court for things, and the court's going to for sure set hearings, and they're going to send the parties to mediation, it's still a flat fee. There aren't going to be any surprises on what the fee is going to be, but certainly it's a lot more work. And so the fee is higher, it tends to be higher, but we always try to work with clients.
Love it. And this one is also slightly service related, but we have someone asking if we offer services for child custody if one parent is not a US citizen.
Yes. I mean, a parent's citizenship, like everything, there's not like an all or nothing answer to this. But yeah, the fact that one parent's not a US citizen has no bearing on its face of whether or not a parent is entitled to ask a court to give them a custody order. That is whether the parent who wants the custody order is the US citizen, or the parent who wants the custody order is not a US citizen. I mean, frankly, the judge and the court is not particularly concerned with a party's immigration status. Now, we don't know what a vicious spouse may choose to do, and what their goals are going to be, and who they're going to notify, and this and that. In my experience, a judge doesn't want to even hear about it, though. It's not relevant. We're here to talk about kids. We're here to talk about what's in the best interest of a child. A person's immigration status isn't really relevant. Now, where it becomes relevant is, did you guys all live overseas and you came here for a trip, and all of a sudden you came with just your child, and now you want to ask a California court to issue custody orders? It obviously will depend on the circumstances, but now now the court's looking and saying, from the court's perspective, do I even have jurisdiction, me as a judge, do I even have the power to enter custody orders in this particular scenario? Have they come here just to request custody, and then they're trying to game or play the other side? It gets a little complicated, but at its core, I would say almost not relevant, very case by case, but almost not relevant.
A lot of great questions here. Okay, this next one asks, my son has lived with me solely for 2 years now. How easy or challenging will it be to file or obtain full custody?
I wish I could ask like 10 subparts to this question. Well, reading between the lines, I'm guessing this person does not have full custody right now, obviously, or they wouldn't ask that. But I'm kind of not understanding. My son's lived with me for 2 years and not having sole custody. So I don't know. I would need a lot more facts on this one, but I would say this, because I think the question presumes that there's some shared custody, which is why the question came up. A judge is going to be unlikely to take custody and visitation away from another parent and give it solely to one parent, unless there's a reason to do that is determined to be in the best interest of the child. And if it's been 2 years and nothing's happened, unless there's some new stuff that's going on, probably not going to change custody. Now, understand there's a difference between custody and visitation. So custody, you've got joint legal custody, where you've got legal custody, you've got physical custody. Legal custody is all about who has the right to make important life decisions for a kid, like schooling and religious affiliation and medical procedures and things like that. Physical custody is who does that child primarily reside with, essentially. Visitation is who has Johnny on Mondays and Wednesdays and who has Johnny every other weekend. That's a different. So I don't know exactly whether that's what the question is going towards. A court would love to just have in every case that there be joint custody. They would love that because it means that the parties are able to communicate, get along, and the kids are having continuing contact with both parents. To take that away is also something different. So what it presumes, I'm thinking in this question, is that there's already been some custody and visitation order entered. The standard for changing a custody and visitation order is a little bit different than the standard for entering an original, a first order. To change an order, you really have to show that there's been like a significant change of circumstances from the time the court last looked at this issue and decided what the custody and visitation orders would be. So the court's going to go back and go, all right, I entered custody and visitation orders 2 years ago, and now we want to change them. To be able to do that, you need to show, there's always exceptions, but you need to show that there's been a significant change of circumstances. What's changed that we should disrupt a child's life and we should, kind of upset the apple cart, as they say? What has changed so significantly that we should make a change in something that's been in place for a long time? It's a little bit harder. It's a higher burden to pass. But sadly, there are many times situations like that. A parent has moved out of state, or parents become abusive, or a parent is now no longer allowing the child to communicate with the other parent, or isn't cooperating in the exchanges, or is habitually speaking negatively about one parent in front of the other. All these things happen. And now you go, well, okay, well, now we're looking at what's in the child's best interest, leaving things the way they are. Is that in the child's best interest? Which kind of goes again to me, something I always say too, which is, I hope all the parents, I'm a parent myself. I hope all the parents that are listening are remembering that, as challenging as it is, and as heart-wrenching as it can be and frustrating, you're the parents, the kids are the kids. And no matter how upset or angry you are at the other side, always protect your children, but try not to put your children in the middle. And I know how hard it is to do that because it's so emotional. But these are innocent. The children are always very, very innocent, no matter what's happening.
This next question we have is interesting. So how does the court view legal marijuana in California?
Really good question. So it's a tough one because this is kind of new. It's kind of new for California. So let's remember, first of all, I'm not a cannabis or marijuana specialist as an attorney by any means, but it's relatively new in terms of its legal status in California. And I say that because it's still against the laws. It's still a crime under federal law. I want to say, but don't quote me, it is listed in the same class or schedule of drugs as things like heroin and cocaine, which is a little crazy. I won't even provide my opinion on what I think about it, whether it's positive or negative. And I hope nobody has an idea how I would think about it, because I'm trying to be impartial. But I think we can all agree that that's a little nuts. Those are two clearly, those drugs are clearly of very different character and nature. I think evidenced by the fact that there have been a lot of states that have chosen to legalize it, but it's still a federal crime. So I think what we should do, I think in looking at this sort of issue, which is how will marijuana use, I think this is what it's getting to, how will marijuana use factor into a family law case? I think two things should be kept in mind. I haven't really thought about this, but this is what I would say. Number one, yes, it's legal in California. Yes, people have opinions about it, knowing that it's also a federal crime. Yes, many judges tend to be older, and so maybe have a different viewpoint than younger people might have. It may go the other way too, who knows, but it's still sort of at least arguably a controversial topic. And so remember that. I think it should ultimately be looked at this in a very similar way as alcohol, though. Just like you should not be drop down drunk, wasted in front of your kids, whether it's legal beer or legal tequila or legal vodka or whatever it might be. It's just not a good, it's not a good look. It's not going to be, certainly not going to be a good look in court. I would take it maybe a little higher awareness when it comes to marijuana, just because of the stigma that is associated with it, whether it's legal or not. Don't leave rolling papers around. Don't leave pipes around. You start doing stuff like that, and now it's like, you add it all together, and it's not a good look. It's not good. By and large, it's going to be about abuse. It's going to be about using it around the kids. I also think smoke plays a role, maybe to a judge. So it's one thing to drink a beer by a barbecue, obviously way more socially acceptable, no matter what anyone's views of marijuana are. Also very different than lighting up around your kid and they're around secondhand smoke. It just feels different. It is different, I think, frankly. don't do it. I think there's no reason for you to do that around your kids. Whether putting aside how we feel about marijuana, just there's no reason to do that around your kids.
Perfect. Great answer. I think that's a good segue to another poll if we want to do one of those.
Oh, let's do it.
All right. Second poll. What does your family law matter relate to? So there's options there. So you can check more than one if you have multiple answers. And we'll give this about 30 seconds as well. Oh, lots of answer coming through.
They're flying in.
Mm-hmm.
Cool.
All right, we'll go ahead.
Let's roll it.
So we see that over half of answered participants, their questions relate to divorce, 67% child custody and or visitation, 31% spousal support and or alimony, 2% prenups and postnups, 7% grandparent rights, and 12% other. Be curious what the other are.
Be interesting. Amanda, were people able to select more than one choice?
Yes.
Yeah. Okay. Really interesting. So, I'm so not surprised by this. It's almost like, I don't know what the other is. Now I'm very, very curious what the other could be. But it's
be a chat if you answered other, because we are curious.
But I just feel like this doesn't surprise me, and I think the reason for it is, if you just sort of look at the spread, it's just so top heavy on custody and visitation. Now, obviously, the second thing that's related there is divorce, because, people who are married and need child and they're getting divorced, if they have kids, there's probably going to be child custody and visitation issues. This is the thing when you've got kids that really almost is like, it's the impediment. It's like that roadblock to being able to move forward, because, and I don't know why, I'm not a psychologist by any means, but I also think, look, it's painful if you break up with somebody you love. It's painful if you've had a life with someone and you've shared, memories, but you're so intertwined and your accounts are together and you own a home together. That's tough. That's painful. But when you get divorced and you don't have kids, if you just aren't going to speak to that person anymore, like that's it. That's the end of it. And it sucks and it's not fun, but you just kind of move on with your life and you get to squarely put it in the rearview mirror. You don't get to do that when you have kids. You can try to do that all you want, but you're not going to do that. So what you need to do is have a new path, just have a new framework of how you're viewing it, and sitting there and harboring hate and resentment. And I know this is a broad statement, because in some cases it's understandable, and it's just the way it is because the person's awful or who knows what. But there's a difference between a person being objectively awful and you being upset with a person for the things they did, which may have been awful, but are not of the type, the real type of awful that I'm thinking about. When you've got kids, if you can't find a way to move forward, and that's why I think counseling is great for people that are going through a divorce, because when you have kids, you need to accept that this is what it is, that it's not fun, that life is going to change, and you don't really just get to put this in the rearview mirror. Don't forget something amazing came out of this relationship, even if everything else failed. You've got an amazing, beautiful, please God, beautiful kid, healthy child or children. And yeah, that amazing gift is also the reason you're not going to be able to completely put this in the rearview mirror. There's birthdays, there's weddings, hopefully. There's, wonderful events and things where you're going to have to do this, and you're going to have to confront it and deal with it. Not easy. So I'm not surprised by this at all. It's such a high friction point.
Mm-hmm. Your mention of counseling brought me back to a question I just saw as well, which I'll go ahead and pull up. What's the difference between confidential and non-confidential parenting counseling?
Yeah, it's a little complicated. I don't want to get into the whole thing of it, but the difference is, and I think every county is a little bit different, so it's very, very challenging. But the difference is kind of self-explanatory. In one case, just like when you speak to a doctor or a psychologist, psychiatrist, there's doctor-patient privilege. The things you discuss are not absolutely. they're privileged. They're doctor-patient privileged, unless you're going to, you indicate to the doctor that you intend to hurt someone, or they have some feeling like you're going to harm yourself or others. They're not allowed to tell anybody the awful things that you've said. If it's non-confidential, then, we've gone there to get counseling. It's open. There's nothing protected about our communications. It's a more complex answer than that, but I encourage everyone to look into that, because it's really interesting concept. And of course, if you want to give us a call at any time, we can really dive into the details and give you a more focused answer.
Absolutely. All right, this next one, kind of playing with fire. Can I refinance my house or sell my house without my wife's written consent?
Maybe. Do you have a prenuptial agreement or a premarital agreement that says you can do that? Are you in the middle of a divorce right now? In other words, we talked about those ATROs, those automatic temporary restraining orders, which prevent you from borrowing. Are you allowed to do that? Now let's go further and say, let's say if you don't do that, you're going to lose your house right now. Well, I think a good argument can be made, maybe form over substance. Like if you don't do it, you're actually allowing the community to lose an asset potentially. And so you have an obligation to preserve assets. By and large, if you're in the middle of a divorce, you should stay away from doing any major big things with your assets without getting a judge's approval, because or of course, an opinion from an attorney who can make sure, give you some confidence or comfort that what you're doing is not inappropriate. So last thing you want to do is just go ahead and do something that probably a judge would have said okay to, but since you didn't ask a judge, now there's major ramifications, and people can lose entire assets. Like they would have had 50% ownership interest in it, but because they did X, Y, and or Z, now they get nothing. They get none of it, because it's considered a breach of fiduciary duty. That's a big component of when you're married. And let's be honest, until you have an order of divorce, you're married. Spouses owe a fiduciary obligation to each other. And I know that's like a fancy word that doesn't mean much in layman's terms, but what it means is, think about an obligation you have to someone, but it's the highest obligation that exists in the land. So like a person entrusts you with their family heirloom or something, and you promise to guard it with your life. That's not a great analogy, but it's a fiduciary obligation is the highest. You owe the highest duties to that person when you have that type of an obligation, and spouses owe that to each other. And so, doing things like hiding assets, having bank accounts that, that the other spouse does not know about, intentionally moving things around, giving away money that you should not have given away because you're trying to hide it, or because you have a gambling problem or something of that nature. You're getting into murky territories with this fiduciary obligations. It's not normal obligations. I have an obligation to treat you nicely, Amanda, to not be horrible to you, right? I have an obligation not to come up and punch you. That's not a fiduciary obligation. That's a much lower obligation. This is it's hard to explain, but it's a very high obligation. So spouses should be very careful when it comes to these kind of things.
Good answer. All right, next question. What sources of income are considered in a divorce settlement?
Divorce settlement. See, they always got to add one word in there that makes it such a complicated answer. In a divorce settlement, the income figures that are considered are the ones that the two parties have decided were important enough to consider in making their agreement, because a settlement means an agreement. I know that's like a cute answer, but I can say what sources of income are supposed to be used. That's going to be your wages, which would include overtime, your overtime. They're going to take into consideration things like required deductions and other things that might come out of your earnings, but also other income, like if you own rental property, are you going to get any rental income? Is there dividend income from stocks? Do you own your own business, or you're a consultant and you're getting other business income? All income is on the table. The real question is why, because if there isn't going to be spousal support and there isn't going to be child support, there's a much less of a need to know somebody's income. You're going to look at assets and divide the assets. A person's income becomes relevant in the, realm of child support, certainly, because it's a mandatory calculation. You just plug in numbers and a computer program spits out what's called guideline child support is going to be. Spousal support, it's not that way. For temporary, it is a little bit. For a permanent spousal support award, it's not using a formula, but it's really just support where the income becomes relevant. Other than that, it's almost not relevant because it's just about assets.
Answer. This next one, what can I do if the custodial parent has a new girlfriend or boyfriend around the child and the non-custodial parent knows nothing about the new girlfriend or boyfriend?
So I'm guessing this to mean that knows that they exist, but does not know anything about them. Would you think that's what they're getting at, Amanda?
That's how I interpreted it. Yeah.
I mean, I think the first thing to do is to, as hard as it is, contact the other parent and say, hey, I understand there's a girlfriend or a boyfriend involved. Can you tell me a little bit about them? I'm happy for you. But Johnny's going to be around them. I'd like to know a little bit about them. Totally reasonable. I think any parent would want and deserves to know who their child, what type of adult their child's spending time with. Is this person nice? Do they have a history of abuse? Are they a sex offender? I mean, who knows, right? Your job is to protect your kid. And I think it's totally reasonable to say, I want to know who this person is. That's always the first step. And I'll tell you why. Number one, again, going back to great communication, which is key, as hard as it is. And I know from a ego standpoint and from a hurt and emotional standpoint, that's not an easy conversation to have. But I'll say this, the more you do it, the easier it becomes, like anything in life. Number two, if your spouse does not cooperate with that request, it's unreasonable. And then you're going to go to court and say, look, I want some information about this. I don't know, I think I deserve to know who this person is. I'm not asking for details. I don't want their social security number, and I'm not running a credit check. But they just they refuse to tell me anything about them. And that alone concerns me, because what is there to hide? The fact that you tried and you did it in writing, right? Because now it's not just your word against them. That's very key. If I just say I called them on the phone, they're saying, no, you didn't. You never called me on the phone. So it's important. If you do that, if you contact them in writing, you try over the phone, they say no, and you try in writing. Now you get to attach that written evidence to your request to the judge. And what that does is make you look like the most reasonable person in the room. And when you get in front of a judge, in any case, whether it's a real estate dispute or a business dispute or a family law dispute, but most often it becomes most important in a family law case, this is a credibility war. That judge doesn't know who to believe. Every single day, that judge sees two people in his or her courtroom who somehow are living the same life and have completely different stories about what happened. They have completely different opinions about what went down. They don't know who to believe. And so it comes down to, who do they believe? And so the more you can do to prop up your credibility, to make it seem like you are the most reasonable person in the room, that you're trying, the greater the chance you're going to get all the things you want and then some. Because that person, that spouse who won't tell you about their new girlfriend, unless they have great reason not to, but if they won't do that, other than looking like a bad guy to the judge, what that also tells the judge is that that parent's not very good at communicating. I'm not inclined to provide any sort of like heightened level of custody or visitation to them, because I'm not so sure they'll allow the child to call mom or dad. I'm not so sure they'll cooperate with drop-offs. So you're really going a long way to propping yourself up. Always remember, put your best foot forward. And what I always tell people is, everything you write, presume it's going to be an exhibit to a document one day in court. So think twice before you send something. And as you're drafting it, think to yourself, am I good? Am I good with this showing up one day in court as evidence? As long as the answer is always yes, roll with it.
Love it. All right, Jeff, we've got 5 minutes left. Do you think we have time to squeeze in one more?
Why not?
All right. So this next question is about adoption. So in an adoption case, if all parties are in agreement, how long does it take to complete the process, and what kind of communication can you expect from the adopted parents?
It's a really good question. I'm going to answer this super quickly so you can ask one other one. And I'm going to answer it by saying, I'm not 100% sure. I'm the first person to admit when I don't, I don't know something. I'll never try to just pass it off like I do. Whenever I've always dealt with an adoption case in my practice, I always have had an associate that handles that because it's not 100% in my wheelhouse. So I don't know. I have some opinions that I think are the right answer. I'm not comfortable just throwing out there something. So let's ask one other quick question. Let's see if we can squeeze one in where I can actually get to.
All right. Let's see this one. How long does it take to receive an answer from an ex party?
From an ex parte. To receive an answer. I don't know exactly what that means. So quickly, and next, I know we're running out of time. An ex parte, what that means is fancy Latin for doesn't really mean this in Latin, but what it is it's an emergency. Normally, when you have to ask a judge for something, this RFO, going back to something we talked about earlier here, you need to serve that at least 16 court days before you can actually have a hearing. It's a process. Sometimes you need an answer way before 16 court days, and that's where an ex parte comes in. It's an emergency. I don't have time, judge, to wait the 16 days. The judge will still set you that hearing. That's going to definitely be longer than 16 days from now. It can be only as quick as 16 days. But you also make an ex parte request, which is I need these orders now. Usually you're presenting that to court the day before, and you're going into court the next day to get your relief or get a denial. So when we talk about a response, I'm not sure if that question is when do we hear back from the court or when do we hear back from the other side? Many times ex partes are without notice. You don't want to give, maybe the emergency is the other side's going to do something, going to do something with my assets or run away with my child. And you don't want to give them notice. That's why you're going in ex parte, because if they find out about it before I get an order, then they're going to do it and it won't matter. But it's quick. It's a quick process. You have a very heightened standard to meet because you're not going through the proper or traditional procedure, but it's quick. Next day, potentially.
All right. Thank you so much, Jeff. So
Yeah,
that is all of the questions that we have time for today. It looks like we have over almost 90 questions, and I wish we could get to all of them. But if you do have additional questions, please feel free to reach out to Marble. But at this point, I would like to congratulate the winner of 25% off legal fees. So check your chat. Congratulations to Danielle T. You have been sent a direct message. Please respond with your email address, and we will make sure to get that discount over to you.
Very awesome.
Yeah, exciting stuff. So thank you guys so much for joining. Just a couple of things to wrap up. So as mentioned in the beginning, we will be sending this presentation as well as a copy of this recording out for everybody to review and reference. You'll also receive a feedback form, and upon completing that feedback form, you will receive 10% off future legal fees with Marble. So we do encourage you to fill that out as well. If you have any additional questions, please feel free to send an email to hello@themarbleway.com. And thank you so much for joining. And thank you, Jeff. This was awesome.
Yeah, and thank you, Amanda. You did a really great job facilitating this, and it was really a pleasure answering these questions that kept me on my toes. I don't know what's going to be thrown at me next, but I love helping people, so I was happy to do it.
Love it. Thank you so much. Have a great night, everyone.
Take care.